Hello students, let us start chapter number 6 in civics, understanding our criminal justice. See, criminal justice. It is a system of practices and institution of government directed at upholding social control, deterring and mitigating crime or sanctioning those who violate laws with criminal penalties and rehabilitation efforts. Those accused of crime have protection against abuse of investigatory and prosecution powers. If anyone violates the laws and rules, so our system gives some penalties to him. There are four main players in this criminal system which is provided by our country. Four main players in this criminal system are police, public prosecutor, defense lawyer, and the last one is judge. First, we will talk about the police. The primary function of law enforcement officials is that of an impartial investigator and protector of public safety. It means police main function is to be impartial while investigating and protecting the public safety. Police officers or sheriffs deputies are the first to respond to the crime scene and first to have contact with victim. The initial information the victim provides to law enforcement is the most critical factor in solving the crime. You can think of police as the gateway into the criminal justice system, the first pillar of our criminal justice system. It is the most important steps as they are the ones responsible for subduing the offender, decide what charges will be filed, collecting evidences, and writing down any other information that can be used to further incriminate the suspect or help the investigation in case that nobody was caught. And the second one is public prosecutor. Who is this public prosecutor? We will discuss about this public prosecutor in the next this one. His role in the court when a criminal case has not been waived or settled out of the court, the prosecutor will summon the suspect to appear in court. The summons comprises the charge and a list of witnesses to be cross checked. The prosecutor may decide to charge the suspect with a less serious offense, example, by disregarding aggravating circumstances. Despite the existence of sufficient evidence to charge the suspect with a more serious crime or may limit the charge to some offenses committed by the suspect. The court is informed in the informal way about the other offenses committed. For the sentence to be imposed, the court may consider these non charged offenses, provided that the suspect does not deny and the offense can be proved. The trial stage begins as soon as the prosecutor has issued a summons. Without it, the case cannot be started. Third pillar of our criminal system is defense lawyer. A criminal defense lawyer works with the defendant to develop the best way of minimize the consequences of any unlawful activity the client may have been involved in. If the client is innocent, so it is the job of the criminal defense lawyer to save him. A criminal defense lawyer may also help to customize a sentence for the defendant that will help to keep them out of future trouble. Most often the case in juvenile means below than 14 years, or family court cases, a good criminal defense lawyer knows the ins and the outs of the local court circuit. He or she is also should know which tactics work for which judges when trying to reduce sentences or even get the punishments from the court. The last one is the judge. Judge plays an important role. They interpret the law, assess the evidences presented, and control how hearings and trials unfold in their courtrooms. Most important of all, judges are impartial decision maker in the pursuit of justice, but sometimes they are also influenced by their position. We, ha- we have what is known as an adversarial system of justice. Legal cases are contests between opposing sides which ensure that evidence and legal arguments will be fully or forcefully presented. The judge, however, remain above the fray, providing an independent and impartial assessment of the facts and how the law applies to those facts. In many of the criminal cases and almost all civil ones are heard by a judge sitting without a jury. The judge is the trier of fact, deciding whether the evidence is credible and which witnesses are telling the truth. Article 22 of our Indian Constitution also protect us from many things. What are those? Article 22 in the Constitution of India 1949. What does it say? Protection against arrest and detention in certain cases. कि no person who is arrested shall be detained in custody without being informed, as soon as may be of the grounds for such arrest, nor shall he be denied the rights to consult and to be defended by a legal practitioner of his choice. Means he also have some rights for his defense. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate. And no such person shall be detained in custody beyond the said period without authority of a magistrate. And Article 39A also tells about the equal justice and free legal aid. The state shall secure the operation of the legal system, promotes justice on a basis of equal opportunity, and shall, in particular, provide free legal aid by suitable legislation or schemes, or in any other way, to ensure that opportunities for securing justice are not denied to anyone, any citizen, by reason of economic or other disabilities. I hope you are able to understand the role played by the police, public prosecutor, defense lawyer and the judge, and how constitution make us aware about our rights. That's all in this video. May God bless you.